Yes, provided it's a genuine retirement account. So what's at work here? Well, let me start with the Chapter 7 context, and then we'll take a step into 13 and 11 based on that concept. So when you do a Chapter 7, the big picture goal is just to erase debts in one fell swoop. At the completion of the case, you get rid of debts without paying anything on those debts. Well, from the creditor's perspective, this is a bit of a hit. So there are some limitations. One limitation in a Chapter 7 is on what you get to keep. You get to keep some stuff, but there's at least the potential to lose possessions in a Chapter 7. So one of the things we include in the Chapter 7 petition is a complete listing of everything you own or have an interest in. And all of those assets get divided into two categories: exempt, non-exempt. The exempt stuff, that's yours to keep, no questions asked. The non-exempt stuff is fair game for the Chapter 7 trustee to take and liquidate and have money to pay your creditors. How do we tell if something's exempt or non-exempt? The Bankruptcy Code has an exemption table, but it permits the states. Remember, bankruptcy is a federal statute practice of law. So everything is federal law. So there is that federal table in the Bankruptcy Code, but the Bankruptcy Code permits the states, if they want to use their own state tables. Some states only use the federal table. Some give a choice of using the federal table and a state table. California, where I practice, is unique in that we have two state tables and we don't even use the federal table. One of those state tables is for homeowners with equity. The other is for everybody else, what I colloquially refer to as the renter's table, although homeowners, if they want to, can use it. Each table has a list of various categories of possessions. Some categories have dollar limits, others have no dollar limits. And our goal as we list the assets is to stick them into those categories so that they're protected from the depredations of the Chapter 7 trustee appointed to the case. Well, let me give you an example of one such category, and this one has no dollar limit: retirement funds. So if you've got money in a 401k, a 403b, a pension plan, those are completely protected. The trustee cannot touch them. But they've got to be real retirement funds, not, well, you've got a bag of money that you've stuffed under the mattress. It's got to, sometimes the somewhat inaccurate statement is used, it's got to be ERISA qualified. There is another federal statute called ERISA that governs the treatment of employee retirement funds. So if you have that kind of retirement plan, it is exempt, and yes, you get to keep it. Now, I said I'd also take a little foray into Chapters 13 and 11. So in Chapter 13 and in Chapter 11, you get to keep all your stuff. No trustee is going to take your possessions and liquidate them. Why is that? Well, because in those chapters, you enter into a multi-year debt repayment plan. And through the plan, creditors are going to be paid. So the trade-off then is you get to keep your stuff because the creditors are going to be paid, but the value of your non-exempt assets plays a role in how much you have to repay your creditors. So the slogan here is the general unsecured creditors must get paid at the very least what they would have received in a Chapter 7 liquidation. So in the Chapter 7 liquidation, if there are non-exempt assets, then the Chapter 7 trustee will take those assets, sell them, have money to distribute to the creditors. So we still go through the exercise of listing all your stuff and dividing it into exempt and non-exempt categories, because whatever the dollar value is, the total for the non-exempt assets, that's the minimum that you can get away with repaying your creditors over the life of the repayment plan. Now, what about those retirement funds? Well, you may remember I said they're exempt 100%. That being the case, they don't go into that liquidation analysis. We still have to list them. You always disclose. One of the big messages here is when you go into bankruptcy, you're having an agreement with the United States of America that the United States will help you deal with your creditors either by wiping debts out entirely or giving you a manageable repayment plan in exchange for, at least in part, full disclosure of everything. So you do have to list your retirement accounts, even though they're completely exempt. So that's maybe a longer answer than might have been suggested by the simplicity of the question, but I think it's important to get the big picture.